Good evening, cohort 10. I'm glad that the weather, road conditions, or illness has not kept us from class tonight. I will now begin discussing the exciting history of judicial prestige that begins on page 53 in your McCloskey book. What? I didn't hear too many of you all clap. Well, let us begin. After John Marshall's death in 1835, President Jackson appointed Roger B. Taney to succeed him. Because Taney had opposed the Bank of the United States and had deprived the Bank of Federal Deposits when he served as Secretary of the Treasury, many viewed him as a political hack and a radical Democrat. People feared his appointment because of the Democratic trend that was hostile to property rights, nationalism, and Marshall himself. However, this proved to not be the case. And I quote, "The old jurisprudence had not been broken down, or even very greatly altered. The nation was not constitutionally fragmented, judicial power was not surrendered. In fact, the position of the Supreme Court as the final arbiter of constitutional questions had become more secure than ever before. The concept of judicial sovereignty, which Marshall had defended against so many challenges, was by 1840 an almost unquestioned premise of American government." End quote. Taney's court decisions dealt mainly with compromise, but upheld some factors of national supremacy. The three cases, which dealt directly with the nation-state problem, are as follows. Mayor of New York versus Milne, 1836. The court upheld that a state could regulate commerce if it was in the interest of the people's health and well-being. In 1851, this case was upheld, and the ruling was that states had the right to regulate until Congress intervened. In Charles River Bridge versus Warren Bridge Company, 1837, the court ruled that states must be responsible for any contracts that they establish with corporations. Okay? Why are you texting while I'm talking? As I was saying, in Briscoe versus Bank of Kentucky, 1837, the court decided that a bank owned and controlled by the state of Kentucky could continue issuing bills of credit. This decision was in clear violation of Article 1, Section 10 of the Constitution, that says no state can emit bills of credit, and was a strong move for states' rights. Despite this, the ultimate mistake that the Taney Court made was to not recognize slavery as an untouchable issue. Several slavery-related court decisions led up to the decline of the Taney Court. In 1842, Justice Story overturned a Pennsylvania law, which he said conflicted with the federal fugitive slave law. Furthermore, he stated that any state legislation that touched fugitive slaves was invalid because the national power over that subject was exclusive. Please pay attention. I promise that I will not be much longer. In Strader versus Graham, 1851, people argued that slaves became free when they entered free states or territories. The court then ruled that the status of Negroes depended upon the laws of the states that they resided in. Simply stated, if a state regarded them as slaves, the Supreme Court was bound by that fact. Now, it gets interesting. In 1856, Dred Scott, who had been taken as a slave into Illinois and into the northern part of Louisiana Purchase, appealed to the Supreme Court in hopes of being granted his freedom. Taney, who is under a lot of pressure to pass final ruling, made three rulings that are viewed as the most disastrous opinion the Supreme Court has ever issued. First, he said that Dred Scott could not bring suit in federal court because he was a Negro, and Negroes are not, and cannot, be citizens of the United States. Second, he ruled that the Missouri Compromise was unconstitutional, so any ruling based on it was void. Lastly, because Missouri law viewed Scott as a slave, the Supreme Court was bound by Missouri's determination. This ruling, which denied the right of Negroes to be citizens and the right of Congress to control slavery in the territories, was very upsetting to many people. This signaled the beginning of Taney's decline. In the years that followed, he was accused of making a corrupt bargain with President James Buchanan because he divulged information to him. He also engaged in constant battles with President Lincoln. This led to Taney accusing Lincoln of being a criminal and demanding his arrest and resignation. When Lincoln refused, Taney's decline continued. Thank you for your patience during this brief overview of the natural history of judicial prestige. For more detailed information, please refer to pages 53 to 66 in your McCloskey book. Have a great night and a great weekend.